Good evening, everybody. Thank you for joining today's webinar. My name is Leah Mwangi. We're just waiting for around 2 minutes. We start the webinar at around 2:05. So I'm just waiting for a few people to join in for purposes of starting the webinar. Thank you so much. Good evening, everyone, once again. Thank you so much for joining this webinar today. My name is Leah Werimo Mwangi. I'm an advocate of the High Court of Kenya. This webinar will be about crypto lending. And I know we've heard so much about cryptocurrency, and today we decided to bring the topic back home and address it on the issue of the aspects. And to start us off on today's topic will be Thomas Guluma. Just a brief introduction of Thomas Guluma is an advocate and a partner heading the banking and finance practice of the firm. He specifically advises clients on areas of corporate law, banking, financial law, merger and acquisition, capital market, and project finance. Thomas has 14 years of experience, having joined the firm as a junior counsel and rising up to the position of a partner. Thomas has experience in commercial and civil litigation as well, including first-hand international arbitration. Thomas currently advises clients both locally and internationally in some of the major transactions in banking and finance, which is a significant power generation project in the financing spectrum. Thomas holds a bachelor's degree from Middlesex University, London, and a master's degree, which is LLM, from Nottingham Trent University. Thomas is a member of Tanganyika Law Society of Kenya, Zanzibar Law Society of Kenya, and the current forum is Africa Law Society of Kenya. He'll be taking us through the first aspect of the topic on cryptocurrency. And in the event one has questions, we can raise the same in the comment section, and the same will be picked up at the end of the session. Welcome so much, Thomas Guluma.
Thank you, Leah, for that kind introduction. I'm happy to be here with you and everyone. Good afternoon. Leah, just a quick housekeeping. The Tanganyika Law Society and Zanzibar Law Society are both law societies in the United Republic of Tanzania, not Kenya.
Thank you for the clarification.
Yes, thank you. So to kickstart, perhaps we can just go straight and dive into the topic. I mean, cryptocurrency is relatively a very volatile and largely very fast-growing area currently around many jurisdictions. East Africa not being left out. Obviously, there's a lot of regulatory challenges that we see, but it's a growing trend now that because the environment is so volatile and it's such a fast-growing industry, we find that we get a lot of advisory requests around the area of cryptocurrency, and the same advice that we give in relation to crypto lending is basically around the lenders now issuing credit in terms of crypto. So crypto lending is actually as I said, is a decentralized financial service that allows investors to lend out their crypto holdings to borrowers. In essence, the interest rates that you get are usually similar interest rates that you'd get in a normal savings account, for example. So I'll look at 6 specific areas, especially when you're using crypto as a lending and you're trying to create security interest by charging the cryptocurrencies as collateral. So the 6 aspects that I'm looking at, I'll look at now. Basically the regulatory compliance aspect. We'll look at quickly at what happens with documentation, then perfection of security around crypto, and then we'll look at the volatility and the valuation of crypto lending, and then we'll briefly look at enforcement and the remedies, and finally the jurisdictional challenges. So when we start with the regulatory compliance, as I mentioned when I started, cryptocurrencies are still very relatively new, but it's a very evolving area. And most of the jurisdictions, for example, in Tanzania, we haven't yet had any regulatory environment put in place to regulate crypto. Obviously, it's most of the regulators are very keen and are being very careful in terms of how you have the regulatory laws and governance, and how to actually address the challenging issues when you have online currencies and then you're trying to trade it and use it as security and collateralize it against lending for lenders. So it's usually what we see for the most of the ELS jurisdictions is still something that I think Kenya is a bit far ahead than us and than Tanzania and Uganda. There's still a lot of discussions that are ongoing. For example, in Tanzania, we've had a lot of discussions with the Central Bank of Tanzania, and currently what we have in place close to the crypto business is the regulatory sandboxes, which they're also quite popular now. So we have actually draft legislation in place. It's still being discussed with the stakeholders. So hopefully we'll build up on that towards getting to the regulatory compliance environment for cryptocurrencies. Of course, one of the other issues that's a challenge is you have to have the regulations that address AML issues, anti-money laundering issues. How do you address KYCs? Then currently the banking industry in East Africa generally, the KYC, for example, requirements are quite heavy. So it's something that we wait to see how it will evolve when you now bring in a regulatory environment on cryptocurrency, and you have to have KYCs. How wide are they going to be? How broad are they going to be? That is something that we are looking forward to. The second aspect is documentation. So obviously, when you're taking security interest in crypto, it's essential to have a proper documentation in place. So, I mean, this is something that we are obviously learning from other jurisdictions, especially the Western jurisdictions, where they've already started doing this, and of course their documents are quite heavy. So in terms of East Africa, one of the things that obviously is important for us to look at is how are we going to have documentation that goes in line with our practice. And obviously, in a typical sense, the documentation will involve creation of the legal agreements. So your usual financing agreements, but then you have to have security agreements in place. Would we adapt the usual, for example, financing documentation, security documentation? How are you going to charge the securities? It's quite essential. Obviously, the agreement has to specify the type and the amount of cryptocurrencies that is being used as collateral, and obviously the rights and obligations of both the lenders and the borrowers. Then once you've had that in place, now you have your documentation is working. Obviously, now we have to go to the next natural aspect, which is perfection of the security interest. So, because you need to ensure that you can enforce this documentation, you can enforce this security interest. Obviously, enforcement will depend on the different jurisdiction requirements for perfection of security. In Tanzania, we've got the Office of the Registrar of Companies, which is basically the registrar has the custody to oversee all the security interests that are being registered in Tanzania, for example. So, of course, this will also involve taking steps such as when you register the security, placing the cryptocurrency in a specified wallet or account, depending on the jurisdiction requirements, and the usual prescribed procedures that would establish priority of security. So, obviously, in East Africa, the different jurisdictions have different prioritization of security. But generally, obviously, so long as you're the first security holder, and security is actually been registered with a proper authority, then your ranking goes above anybody else who will come at a later stage. The fourth aspect, obviously, is volatility and valuation. Cryptocurrencies are known for their price volatility. It spans out in and out. It's very rapid, and this can represent challenges when assessing the value of the actual collateral. So it's always important to consider mechanisms for valuation. I mean, obviously, different banks or rather different financial institutions may have different mechanisms on using maybe an agreed index or relying on independent sources to determine the value of the cryptocurrencies for which collateral is being offered. And obviously this has effect with what will happen at the time of enforcement. So that's one of the biggest challenges that we see that will need to be addressed. So the next aspect obviously will be enforcement and remedies. And this is obviously in an EOD event, an event of default, the lender will obviously seek to enforce the security interest. But enforcing security interest in cryptocurrency from general experience in most jurisdictions is quite complex, because often enough it involves accessing the wallet, transferring the digital assets from wallets to accounts. It can be quite challenging and complex. So it's important to understand the technical aspects of the cryptocurrency transfers between wallets and accounts, and obviously having the appropriate legal mechanisms in place to facilitate such an enforcement is quite crucial. Of course, this also goes naturally now to my other point, which is the jurisdictional challenges. And cryptos operate on a decentralized and a very huge global scale. So this can create a lot of jurisdictional challenges. I mean, different wallets in different jurisdictions with different laws. How do you harmonize the laws? I suspect that's one of the main reasons why many jurisdictions have not yet had a regulatory regime to address crypto. So it's becoming very, very complex. But some of the jurisdictions that do it, they already have set some sort of like a roadmap. But again, adapting that will depend on each jurisdiction liking, or rather the practice of the jurisdiction and the regulator, which in most cases being the central bank. So those were my points and the initial aspect that I wanted to touch on as an introduction to this topic. Thank you very much for listening.
Thank you so much, Thomas, for that well-detailed explanation on cryptocurrency and how it needs to be gone about in terms of its application, the jurisdiction, on what we need to look out for in the event a certain jurisdiction intends to take it up as security. We will take up the second panelist as then the questions will do at the very end of the session. So allow me to introduce the second panelist, and his name is Amanya Timothy. Amanya Timothy is a senior legal officer, litigation at Finance Trust Bank. He has a remarkable professional experience in law, and he's an in-house legal and offers in-house legal. He's a holder of bachelor degree in law from Nkuba University, a postgraduate diploma in legal practice from the Law Development Center, Kampala, and a master's of law from the University of Western Cape. Amanya is an enrolled and active advocate of the High Court and all other courts subordinate to it, and is also a commissioner for all. He's a member of various bodies, including East Africa Law Society, Uganda Law Society, and Uganda Law Society. He has also attended and continues to attend various professional trainings in continuous legal professional development and corporate governance. He's also an academic and researcher with keen interest in law and its linkage with leadership, in the leadership and technology, human capital, or resource personnel management. He'll be taking us through the second aspect of the topic, and we welcome you, Amanya, for the session. Thank you so much. Amanya, we can't hear you yet.
Yes, I was saying thank you for that introduction, and then also Thomas, the previous speaker and panelist, that introduction. I'll be going through the other aspects of this particular presentation.
We've lost you a bit, Amanya. All right.
Okay.
Yeah, we can view.
Crypto lending, legal implications of taking security interests in cryptocurrency. I'll go straight to two questions in my presentation. What are crypto assets or currencies? And then what is the space for crypto assets in modern credit financing practices, which some people have left out into crypto lending, and also using the cryptocurrency or assets as one collateral for borrowing as a departure from the usual or the traditional lending or collateral that is used. Cryptocurrencies, according to Investopedia, is a form of digital assets that is based on a network that is distributed across a large number of computers. And this takes the form of what we call decentralized digital currencies. And they are commonly operated on the blockchain technologies. And as we have heard from the previous panelists, they continue to take an aggressive space in the money economy in the world. And they are trying to reshape the meaning of currency in the highly digitized world. As you're aware, there's a growing change from the traditional way of doing things, and rather now technology has taken the space. So these decentralized currencies are a birth of the fourth industrial revolution, and that has been for the past 3 decades, changed everything about how we live. As at last year, that was at 2022 December closing, there were over 9,310 cryptocurrencies in the world. And these were privately owned largely by companies and individuals. At the regional level, for example, in Uganda, they remain unknown. The reason has been that they are largely not recognized as currencies, at least in Uganda. However, the Central Bank of Uganda, for example, has taken the steps towards creating a similar currency that has sometimes been known as the central bank digital currency. These cryptocurrency or assets then draw a number of characteristics or features that spell out for one to be able to determine that this is categorized as a cryptocurrency, this is categorized as a crypto asset. One of them is that they're decentralized. In other words, there's no central authority. In traditional fiat currencies, we know that central authorities and banks do control the financial system. This can be expressed based in the various evolutions of money. We know that we have had 4 evolutions of money. The first one being in 1900 to 1933, where we did have the gold standard era. And during that particular era, the value of the physical gold held by a country did mark what was the value worth of that particular country or nation or company. We then went into the Great Depression of 1930, into the Bretton Woods era of 1934 to 1971, and we later slide into what we call now the fiat money era that starts from 1972 to what we have presently. And that was dominantly, normally, with a normal medium of exchange that was given that is neither a commercial commodity nor a title to any such commodity. And as such, it would have gone to the extent of papers, coins, or any aspect that is given such value that is derived from the premium based on a collective trust in a given country or nation. When it comes to the cryptocurrency or the crypto assets, it's worth noting that the same are not centralized and they do not have that kind of regulatory context when it comes to central authorities such as the central banks, among others. The other thing is that it is irreversible and immutable. In other words, once it has been done, oftentimes it cannot be undone. And it should be impossible for anyone but the owner of the private key, because these cryptocurrencies, operation of these cryptocurrencies or crypto assets largely dwells on use of this on the use of private keys. It is important to note that the reversible and immutable features of cryptocurrency mean that it is impossible for anyone apart from the owner, the underlying word being the owner of the respective private key, to be able to move their digital assets, and the transactions cannot be changed once they have been recorded in a given blockchain. It is also worth noting that also it is possible to change the transaction ledger, because these transactions are often put on the record in what is called a public ledger within the blockchain technology as an organization between peers and peers, a reflex of what transaction has been conducted between those particular peers or persons that are part of that particular transaction. Again, it also highlights that it is anonymous. Why? For example, when you look at the trace of the history, whereas we know, or we have been, it has been written that the cryptocurrency was created in the late 2008, and that was following, of course, the global financial recession by one Satoshi Nakamoto, which happens to be a pseudo for the founder of Bitcoin. And of course, to date, there have been reports that his identity remains mysterious. So, of course, the inspiration comes from the DigCash, which comes in 1990s through the white paper that was published in 2008. And when you look at the usage and the forms to date, once it's somewhere, the identity that is taken is rather not any other detail. For example, the preceding panelist highlighted, when you go to the traditional way of borrowing, the traditional way of lending or transacting with a bank, with a financial entity, you're going to be required to do the KYC. know your customer, where you're going to get the details about the person, the names, their age, stretching even to the address, the contacts of the person, and you get any of those other details. But when it comes to aspects of cryptocurrency, the identity of the users then is not let out there. So you're dealing with anonymous persons, but rather because you're dealing with this technology that has been established, and there's that kind of safety because there is that private key and public key, but also the aspect of the public ledger that records the transaction. This is an aspect of limited supply and scarcity, and we know that fiat currencies have an unlimited supply, as oftentimes these central banks can issue and will print as much fiat currencies as they want. However, these central banks are often accused of manipulating the value of the country's currencies as part of their economic policies. And oftentimes, there's been disagreement between economists and some of those that really are into the influence of the value of these currencies in as far as the position with regard to the value that is attached to that particular currency is concerned. The inflationary nature of fiat currencies would mean a decrease in the value of the currency over time. And when it comes to cryptocurrencies, we have a limited but yet a predetermined supply of the cryptocurrency that is coded into the underlying algorithm when it is created. And largely, it is because it is to the user. The creation comes from the user and the value that they have at the particular time that they're able to offer or to have into the system. With cryptocurrency, however, no individual or consortium is able to affect the supply of currency, exert significant influence over it. And like I highlighted earlier, that stems from the aspect that it is a creation of the user and largely controlled through the systems. Many top cryptocurrencies such as Bitcoin, Litecoin, and Dash have a maximum supply, making them deflationary by nature. And therefore, any increase in the demand or adoption of the cryptocurrency will cause corresponding increase in the price of value. When it comes to classification, there is no common and globally accepted classification of cryptocurrencies in the different jurisdictions. And of course, each country and each region appreciates the aspect of cryptocurrency or digital currency in their own way. And it goes to one, the legislation that relates to that particular cryptocurrency. It also relates to the appreciation of the controlling authority on what amounts to cryptocurrency in that particular nation and how the same is dealt with, and whether persons can transact in the same, and whether it is actually even recognized as being legal. And except for jurisdictions where they have been accepted as alternative currency points, the rest of the world classifies them as digital assets, commodities, a form of gambling, and in other jurisdictions, they remain unclassified and regulated. And as at that time, the global market capitalization had reached at $2.95 trillion, which of course is voluminous and should raise questions as to taking interest into the areas of crypto or use of crypto. In Uganda, we have had some jurisprudence in as far as cryptocurrency is concerned, and the court in that particular matter of Silva Kayondo versus Bank of Uganda. Court was hesitant on mentioning its position with regard to whether these cryptocurrencies amounted to assets or not, and whether actually they are legal, but rather followed what the Bank of Uganda had issued in their directive earlier in the year. Then in the case of Internet and Mobile Association versus Reserve Bank of India, crypto we know was classified as digital and the virtual asset. It's now taxed in that particular jurisdiction, and people have gone ahead to transact, but also to do extensively what they call crypto lending. What then is the space for cryptocurrency assets in lending and borrowing financial business? It's worth noting that lending or borrowing in itself is contractual in nature. In other words, person A goes to this entity B, being an individual or company, one that is licensed to do the same as or to transact business or financial institution, offers to be extended to credit or loan facility, but then offers in return collateral or some form of kind of security. And therefore, security interest in that property or collateral is important as an unenforceable claim or lien in that security that has been pledged to obtain that loan. And normally, the effect is that the entity should be able to recover their loan, and also in exchange of that particular property or collateral, the owner who is giving in that right, in as far as they get the loan facility, should be able to get the right to repossess all or part of the property, the borrower, once the loan payments have been done. The lender also has an option, of course, once the loan has not been paid, to dispose of or deal with the security with an intention of obtaining back their money as well as the interest. That's why actually all these financial institutions or lenders or lenders are into the market. The Uniform Commercial Code, which was established in 1953, gives 3 requirements for security interest to be legally valid. That's for you to be able to spell out that you have a security interest that is genuine, is enforceable, that is going to be able to give you back value worth of the money that has been issued alongside the interest and other values. The same must spell out 3 things. Number 1 is that the security interest is given, it has a given value. So you're not going to just get something that can not be able to regain back the finances that you're giving out to this person, and then you say you've given money or lent money out of and given collateral. The borrower must own the collateral, which speaks to the aspect of ownership of that collateral. Now that's the right to use that particular property free of any other encumbrances, often that these should be able to aid the lender to be able to recover back the monies. But also the borrower has signed, which is the third aspect, that he has signed a security agreement, and the collateral must be specifically described in that security agreement. And when it comes to the aspects of cryptocurrency or lending against crypto assets, the question is then, does it fit within the 3 contexts of the security interest having values, the borrower owning the collateral, but also the ability to reflect the same in a security agreement or a loan agreement or facility agreement, dependent on the nature of the transaction? Are you able to describe specifically that particular collateral? If I have digital assets, if I have cryptocurrencies as what I'm offering as a collateral, can they be properly described in the facility agreement? That in case, say, one is unable or refuses to pay back the loan or facility, are we then able to claim against those crypto lending? There have been a number of parameters, again, like the earlier panelist highlighted, that then speak to the aspect of whether or what would be the legal implications for potential lenders. For example, preparation, due diligence, structures, and characteristics. When we speak to elements such as compliance with the regulations, what does the law say within that given country? When we talk about protection of lenders against the market volatility, look at the aspect of the risk of loss of collateral in case of recovery. Are you able to recover in instances where you have crypto assets, which represent a large portion of the secured collateral? If we are to look at the aspect of use of cryptocurrency, what do we deal with as due diligence? Remember, in the earlier discussion, I highlighted that one of the key tenets, the key features of the crypto assets or the cryptocurrencies is anonymity when it comes to the users. Then when it comes to due diligence, how does one perform that due diligence? Because we know that when it comes to lending or borrowing, the aspect of due diligence is one critical one, and it's very important And before granting credit facilities to any borrower, the lender must take all steps to ensure that all the due diligence has been fully done when it comes to crypto assets, to make sure that all cryptocurrency wallets related to the collateral under the loan agreement are disclosed in sufficient detail. But then you look at instances where you're dealing with a person in a country X, person in country Y. How do you then supervise that due diligence? How do you ascertain the details that come with the information that has been relayed to you? How do you deal with it? How do you come up to the aspect that this is genuine information, this is genuine details that have been provided by the person on the other end? When it comes to the terms of payment, lenders and borrowers must agree on a method of repayment of the principal. When it comes to these crypto loan agreements, how clear are they? The nature, the frequency, and the value that you attach to those particular things. But most importantly, when it comes to the aspect of collateral protection and digital risks, instances where we have had such as cyber theft, phishing, scams, and loss of access of information, such as keys and passports. And we know that oftentimes cryptocurrencies undergo changes in their blockchain protocol. And these oftentimes may have an effect on the collateral, such as splits, can also extend to token swaps, can go to rollbacks. And then the question would be that as lenders and borrowers or the stakeholders within that chain, should you choose to adopt the same? And you should be able to establish a contractual, but rather a more practical protective measure that should be able to safeguard the collateral and access when it comes to such instances. The biggest question normally comes with enforcement of those security assets. And the aspect is that normally, of course, enforcement is guided by the law, the legal provisions. Then there would be challenges in instances where a country or given region does not recognize the legality of some of those currencies or does not recognize the transaction. Then one would wish to know, then how do you recover the same from that person? So through the region, the regulators have adopted the Bank for International Settlements, and these including prudential standards on dealing with credit facilities and asset class. It's important to note that the standards are comprehensive and they have set out a number of aspects that have been adopted at the domestic level. Such instances include categorization of banks, capital and liquidity requirements for banks, as well as risk management. It's also worth noting that within the context of East Africa, some of those requirements have been reflected in capital requirements for commercial banks, credit classifications, as well as restrictions that have been issued with as far as lending and borrowing is concerned, and sometimes the context of the assets, the nature of the collateral, and how the same is dealt with. The liquidity requirements that have been set out by the domestic laws that do regulate the financial institutions in the region. Of course, these standards have evolved over time, and it's important to note that the weaknesses that were identified during the earlier financial crisis have been attempted to be answered in the Basel IV framework. Although, of course, most high-income countries have adopted these standards, adoption under the middle income and the lower income, where some of us do fall, have been so challenging, especially when it comes to the aspect of the complexity of the rules. The role of the standards in crypto asset collateralization. Of course, like I highlighted earlier, the existing standards on other asset classes, especially on capital requirements for commercial banks, credit classification and restrictions on lending and exposure, liquidity requirements can be used facilitating access to credit by the crypto asset holders. I wish to note that indeed recently there was a finalization on the BIS standards where we have been given guidance and there have been set timelines with this document set out to have its final standards, which the committee has agreed to implement effective 1st January 2025. These standards by far are important for two reasons. And it stems from the previous discussion that we've had in as far as the nature, the features, and dealings in cryptocurrencies is concerned. Number one is that they attempt to classify crypto assets according to the risk exposure, and they offer mitigating consideration standards that will be followed by the regulators and financial institutions. They also provide for group classification of these assets, and I'll go into details of those particular groups. Number one is that in group one, they talk about crypto assets that meet the classification conditions set in tokenized traditional assets that meet the classification conditions. When we talk about the tokenized traditional assets, we are dealing with aspects that involve the digital representation of real physical assets such as stocks on distributed ledgers or issuance of traditional asset classes, but now in a rather tokenized form. We create those tokens and then you can be able to deal on the platform. These crypto assets with effective stabilization mechanisms that meet classification standards. When you're dealing with classification one, where we talk about tokenized traditional assets, is that the aspect is that tokenized traditional assets will only meet classification in condition if they satisfy all the following requirements. Number one, they must be digital representations of the traditional assets. That will be using cryptography or DLT. In some countries, I understand there have been movements into Electronic Transactions Act, where they have catered for some of these, such as smart contracts, and they have also catered for the cryptography and also the DLT. Then there's also the aspect that they must be able to pose the same level of credit and market risk as the traditional forms of the asset. The traditional forms of the assets being, for example, things like land. When it comes to things like checks, the initially used forms of collateral. In other words, for these to be able, the tokens must have that particular value to be able to bring out that aspect. In practice, this means that the following tokenized traditional assets, such as bonds, loans, and claims on banks, equities, and derivatives, should be able to be tokenized and have such value. The crypto asset in itself must be able to confer the same level of legal rights as ownership of these traditional forms of financing. For example, the right to cash flow and claims in insolvency. And that's what we talked about earlier, the ability for one to be able to recover the net worth value of the loan, for example, but also interest and any other aspects that may arise, such as recovery costs from that particular crypto asset. Therefore, there must be no feature of the crypto asset that could not prevent obligations of the bank being paid in full when due as compared with the earlier traditional assets, such as land. The other categorization would be commodities, that these crypto assets must confer the same level of legal rights as a traditional account-based record of ownership of such property. In other words, one should be able to register the alien on that particular asset. These BIS standards go further to bring in the second category. And that second category is that these crypto assets are those crypto assets that fail to meet the classification which I've talked about. The classification being that they have the value, they confer the same legal rights as the traditional ones, but also the ability for the lender or the bank in this case to be able to recover their monies or their worth and any other expenditures towards recovery of that particular property. Now, these BIS standards are saying that if you're not able to fall in that category one, then for you to be able to use these digital assets, crypto assets, at that point in time, then they fall either in category two. And in that category two, they say that these crypto assets, such as stable coins and unbacked crypto assets that fail to meet the classifications, but pass the group two hedging criteria. And these must be able to meet the following. One, they need to be redeemed. So the aspect again goes to the reason for lending, that you're not you're not a donor. You're not just giving out gifts. You should be able to recover what you've dealt with. For example, you know that in banking, someone has given you their money. This is client's money that you're dealing with. And as such, you should be able to recover back the money, but also as being an investment, you're obliged to make sure that, of course, there is return to an investment that's made, of course, by the shareholders. And as such, there must be that return. So they're telling us that for them to be able to be relied on or used as security in the second category, then if they do not satisfy the first points, then they should be able to be redeemed or converted into traditional assets. And then they should involve additional counterparty credit risks that are relative to the traditional assets. In other words, there should be ability to do the diligence and ascertain the genuineness and value of those particular assets. The stabilization mechanism, on the other hand, enables the risk management to cater for aspects such as fluctuation. You must have noted that earlier I did highlight instances when it comes to enforcement, collateral protection against the digital risks, instances where we have had aspects of phishing, we have had instances of cyber theft, loss of access of information, and this relates to keys and passwords. Of course, like I highlighted, cryptocurrency largely deals with use of these primary keys. So this other mechanism then comes in to try and minimize those fluctuations, but also the loss of value of these crypto assets on the market, which is largely dependent on the use by on the users of that particular currency. It's important to note that banks may use the assessments of independent third parties for the purposes of verification of ownership rights, and that is only if they are satisfied assessments are reliable. Of course, this is to underpin the relevance or the importance of doing due diligence before one seeks to rely on a particular collateral in case they are to regain back their monies. And then the other aspect is what we call the redemption test that needs to be applied when it comes to the aspect of cryptos. The objective of this test is to ensure that the reserve assets are sufficient to enable the crypto assets to be redeemable if at all times the peg value, including during periods of extreme stress, but also to be able to pass the redemption risk test, the bank must ensure that the asset arrangement meets the following conditions. Number one is the value and composition of reserve assets. And under the value composition, the value and composition of reserve assets, we're dealing with the net on all neo crypto assets, on the claims of these assets. And these must at all times be able to be redeemable. The other aspect is asset quality criteria for these reserve assets. And of course, these crypto assets are pegged to one or more currencies. The reserve assets must be therefore comprised of assets with minimum market and credit risk. The underlying fact words there being the minimal market and credit risk. And then the other aspect is management of reserve assets. And therefore, the governance arrangements relating to the management of reserve assets are required to be comprehensive and rather transparent. This requires that the reserve assets are managed and invested in an explicit legally enforceable objective, ensuring that crypto assets can be redeemed promptly at the peg value, including such periods. Then what becomes the role of the commercial banks under the new BIS standards that we see are then set to be taking action come 2025. That's just barely a year and a half or so from now, because we're dealing with January 2025. Banks on an ongoing basis are responsible for assessing whether the crypto assets to which they are exposed are compliant with the classification conditions that have been set out in those standards. Therefore, goes to say that these assessments will determine whether these crypto assets fall within the classes that have been provided, being Group 1A, Group 1B, 2A, and other groups that have been highlighted in those BIS standards. Of course, banks will be required to put in place the appropriate risk management policies because we're dealing with digital instances, and not underscore the growing trends, of course, of cyber fraud. And therefore, we must have in place procedures, policies, even and IT capacities that should be able to evaluate such risks. And banks, therefore, must fully document the information used in determining compliance with the classification conditions and make these available to supervisory authorities on request. Such instances can be through thorough due diligence, and therefore, when you're dealing with cryptocurrencies, you should be able also to observe and carry on the aspect of knowing your client. However much one of the characteristics or the tenets may seem to be that they point to the aspect of anonymity. We have an aspect of minimum credit requirements for credit risk that has been spelled out by the standards. And as highlighted there, for example, when it comes to the tokenized traditional assets held in the banking book, they will generally be subject to the same rules to determine credit risk-weighted assets as non-tokenized traditional assets. In other words, the rules that have been set out in the credit risk standard earlier will be then used in this particular category. The same standards spell out for the various groups when it comes to Group 1B as well as Group 2. The foregoing standards going forward are going to shape how banks treat crypto assets as an asset class, and they are dealt with by commercial banks and any other financial institutions. These cryptocurrencies or assets have been described as highly volatile, speculative, that they are likely to pose instability to the financial market, of course, given their digital nature and the way those transactions are conducted. Of course, it's compelling that eventually from 2018, there have been declines in some countries, but also some increments in some countries. It's important, therefore, to pick a leaf from those standards because these standards stem from an association of at least those of central banks upon which some of those standards have been picked and then reflected even in the regional regulations and the laws. Therefore, we need to regulate crypto assets, recognize them, and as an asset of class, and the reasons being, among others, that that's the trend and it's a risk, but also it is one of those possible areas that are likely to pose a competition in the use of the banking. Of course, previously, there have been those suggestions that cryptocurrencies tend to take away the use of trust of the third party, the role of, for example, a bank in a transaction. However, when you look at those standards of the BIS and the trend that we seem to be taking, look at eventually the banks or financial institutions will have a role to play to be able to tap into the increasing use of these particular currencies. For Uganda, the current regulatory framework seems to be risk aversive, and whereas the asset class has globally expanded, attempts to expand the scope to include the assets remains limited, but of course, both in law and in practice. And of course, until 2019, when the Securities Interest in the Movable Properties Act was enacted, which law still seems to provide some gaps. Of course, it has been subject to interpretation by the courts, and the legal regime seems to still not put out the use of cryptos as legal in the country, and the same remains rather unrecognized within the country. Of course, there have been attempts by the central banks lately to try to create what they call central bank digital currencies. And of course, they have rather not been effective at the moment, but we deliberately wait to see how it goes, that particular aspect. So, is all lost? No. We still leave it to the financial institutions to take the drive, to take the lead when it comes to the aspect, but also to take into consideration that innovations such as crypto assets are no cover in the existing legal framework when anyone wants to read into the provisions of the laws within the context of Uganda. I've seen in some countries within the region, at least they've adopted some of those aspects, and adopted items such as the smart contract, cryptography that seem to embrace the aspect of use of these crypto assets, the use of cryptocurrencies or digital currencies. Cryptocurrency assets have no global accepted definition, largely, but also when you look at other constraints such as skepticism, when you look at things that have happened, for example, in the past where they have been lost into the system, and such instances, people tend to draw away from investing into such or use of such cryptocurrency. And as a region, we must appreciate that we have not largely invested into the digital infrastructure to enable us to undertake use of crypto assets. And yet, the growing economy, which we interact with in the other countries that have taken on or adopted this system, that seems to be the way to go. Recommendations that as a region, we must keep a watch of the BIS standards, which have previously and recently given a trend of the direction on aspects of the financial market. And eventually, these standards should be able to speak to the risks that have been associated with crypto assets. And perhaps over time, people should be able to appreciate the value or the purpose of use of crypto assets, cryptocurrencies, and perhaps these financial institutions should be able to be more proactive through investing in research, but also be able to tap into the spaces so that they can remain relevant in the financial market. As I highlighted earlier, the philosophy behind crypto assets is to decentralize financial flows. However, when you look at the BIS standards and where we're heading, it's rather important that financial institutions are going to play a very important role in the growth, which is the aspect of trust as a third party in a transaction and in the use of these digital assets or crypto assets. And as such, you need to pay keen interest, but also the need to deal with the aspect of ignorance and skepticism, especially among the stakeholders, clientele, and also influence policy and regulation in as far as cryptocurrencies is concerned within the region. With those few remarks, I wish to bring my presentation to a close and hand over to Mwangi. Thank you for listening.
Thank you so much, Amanya, for that well-detailed presentation. Clearly, there's so much out there in terms of the legal aspect of cryptocurrency, and I'm glad to know that the courts in Uganda have actually ruled, especially in this Silva Kayondo case, knowing that at least what we currently know the minds of the courts. We can now move. I have seen in the chat section, there are various questions to which I'll be reading them out. Before I read them out, Annette Nyakora has requested whether she could get a soft copy of the presentation. Maybe Amanya can share the same with Gabriel. Maybe it can be circulated across board. We can start the questions. The first question that has been asked, I'll be reading them in twos. The first question by Paul Kaunda. Thank you, Paul. He asks, Councillor Amanya, can you share your experience on how law enforcement organs can reveal the identity of criminals trading in a blockchain? And then question number 2 by Akichoth. He asks, thank you for the in-depth presentation. I would like to be enlightened on any steps being taken by banks operating in East Africa to take advantage of the opportunities in the cryptocurrency space. Over to you, Timothy. Amanya, did you hear the questions, or could I repeat them?
We could repeat the questions. And some
yes.
was, yeah.
Okay, the first question was, can you share your experience on how law enforcement organs can reveal the identity of criminals trading in a blockchain? That's clear?
Yes, that's clear.
And then the second question by Akichoth was, thank you for the in-depth presentation. I would like to be enlightened on any steps being taken by banks operating in East Africa to take advantage of the opportunities in the cryptocurrency space. That's the second question.
Okay. Thank you very much for the questions. When it comes to the aspect of revealing identity of criminals that are trading in the blockchain, well, I highlighted one of the limitations in the region as the infrastructure. We seem to have invested less in the infrastructure when it comes to aspects of dealing with cryptocurrencies. However, in instances, that doesn't mean, of course, just because the law doesn't recognize the use of those currencies, doesn't mean that people have not traded in them. There are a number of people that have gone ahead to trade in some of those currencies. And I would believe that within the context of having proper cyber investigation units, cyber investigative departments, then you should be able to have software that you've been able to use within for identification of such instances where there have been those frauds. I highlighted earlier that when it comes to technology, of course, there are always those instances. You're going to have instances of phishing, instances of cyber attacks. Of course, because people are always on the look to try and get out something, especially through those channels where you're dealing with anonymous persons. But again, one important thing is that normally for you to transact on that crypto, especially because you see the way cryptocurrency applies, it normally deals with three things. You have what we call the peer-to-peer, where one user on the end and one user on the other end is able to deal. Then we have peer to contract. In other words, you have one person who is the user being the peer on one end, but also is connected to a pool of other people, but they deal on the same platform, but using contracts. And then you have also, again, what we call the direct lending, for example, when it comes to crypto lending. And then you have those lendings directly through money from the borrower to the lender, but they're also, again, peers or users. So until such a time, then when one user on the one end or the contract on one end comes out and then maybe says there's an issue, then you have to set into play the cyber mechanism, the cyber tools that you have. Is your team robust enough to be able to do that detailed investigation? Because you're dealing with anonymous persons, you're dealing with persons that their details as to their identity may not be so much available when it comes to the internet space. But then, of course, there is always going to be a way. It's a little bit, of course, costly because now you're dealing with persons in different jurisdiction, one, but also instances where you don't have control over the persons. But what's important is that there must be a robust system when it comes to cyber investigation within that particular entity or nation to be able to rise to the occasion when such instances or challenges are raised. How are the banks within the region trying to take advantage of the situation? I highlighted my earlier presentation. There have been attempts, for example, by central banks in the region to try and create what they have called digital currencies. And of course, the aspect of these digital currencies is to try and divert away from the usual aspect of how people deal with some of those things. And the difference largely between that central bank digital currency and the cryptocurrency or crypto assets is largely the aspect of decentralization of the currency and centralization of the currency. That when it comes to these central bank digital currencies, they're going to be more centralized. You still have control regulation over them as opposed to the cryptocurrencies. In other words, this now comes rather as more of an effort by these central banks to try and counter the aspect of cryptocurrency. But like I said, then some of these members some of these member banks, central banks, are members again of the BIS framework, the Basel Institute framework, and they have subscribed to some of those standards. And like I said, it's a reflection. Some of those standards that have been set by the BIS, again, have come here and have been implemented in our laws, in the regulation, in the various circulars that have been issued. And over time, of course, once those standards that we, according to the BIS, are set to be implemented come 2025, then there is a possibility that then the central banks may move away from their own move of central bank digital currencies, which may have not been implemented at that time, try and go further into ascertaining the importances into this. Now, the question, when it comes to the banks within the region, the advisable option would be taking advantage. How? Digitalization. Try and create mechanisms, move ahead of times, look at things like how do you do the due diligence when it comes to issues of using cryptocurrency? How do you enforce? The other areas we looked at, we highlighted earlier, things to do with the due diligence. How do you ascertain the value? How do you deal with the aspect of policy and regulation? Are you going to, as banks, move into the direction of pushing for the policy framework to be put in place that should be able to enable you to transact when it comes to cryptocurrency? Are you able to deal with the collateral? If the monies have not been retrieved or have not been able to recover from these crypto assets, how are you going to be able to deal with them? For example, there can be an option that, yes, whereas you're going to embrace use of cryptocurrency, crypto assets, digital assets as a security or collateral, then let us have an option where this person is going to have an additional security. In other words, where there are instances of the value downgrading with regard to the crypto asset, then you're able to recover from the additional asset that has been put in place. When it comes to aspects of terms of repayment, when it comes to documentation and standardization of these contracts, are you able to draft these smart contracts? Are you able to draw these smart contracts that you're able to deal with this other person on the other side, on the other interface, or on the platform that has been put in place? I think it is one of rather being more proactive, be able to move ahead of time within those standards, because eventually the standards will come up with us and they should be able to apply.
Okay, thank you, Timothy, for that detailed response. I believe Paul and Akichoth, we've answered you. Paul also had another question. I need to know your take, that is, Amanya, I need to know your take on whether crypto trading is strictly decentralized in the sense that there's no human intermediary, or there are some circumstances of centralization. He also adds and says that, are there on-chain dispute resolution platforms to accommodate crypto disputes? I can also read one more question. I believe, Amanya, you've gotten the first question.
Yes, whether I did get it.
Okay, let me read the second one from Hannah Kitonga. She asks, without a global accepted definition, how are the banks to assess their true risk with crypto assets? And goes on to ask, if the accountant stroke auditor use a different valuation for the assets from the banks, or if the valuation fluctuates haphazardly, how does the bank manage its financial or assess its risks? Over to you.
Okay. The aspect of being decentralized, decentralized currency arises from the fact that the same operates independently of a central bank or governing authority. And largely the problem that comes with this decentralization thing is the regulation, the aspect of regulation. How do you regulate, for example, when you look at, again, the components, the futures, the tenants, something to do with anonymity, someone who is existing out there, someone is in Nigeria and they're trading with someone in Uganda. and you're dealing with money off the surface of value, this asset, this crypto that is somewhere in the space. And the same really is just an interface of technology, because you're dealing with the use of keys. Because these decentralized currencies are built on that blockchain technology. And when you look at the blockchain technology and how it operates, it's rather a distribution of the public ledger. In other words, it records each transaction, but in a secure and transparent way. So person X, who is a peer, person B, who is a peer on the other end, deal on that particular chain of technology. So in that way, and that's the reasoning, the rationale why most of these courts, and it's one of the areas that have raised this kind of skepticism. How to regulate, how do you deal with the person that is in such a space? The law at sometimes may not even be able to absorb the kind of nature of the transactions on how they are held, and how it is done. In other words, when you look at how it is designed, is that it is designed in such a way that it is to be secure, but also tamper-proof. In other words, it makes it ideal in such as finance. Of course, like I said, from the history and how it comes into play, how these people come up with this aspect, is that when you look at that white paper, is that they largely looked at the aspect of transaction, electronic transactions and electronic payment systems. How do you deal with the person and then yet exclude the third party who is now playing the aspect of the trust? In this instance, the third party being a bank. So in view of the same, to answer your question, one would say that cryptos or cryptocurrencies or crypto assets, they turn out to be rather a more decentralized way, a decentralized approach. And there's that limited interface of the centralization aspect being into regulation of that particular arena. One can only live to tell whether eventually, of course, with such regulation and robust laws that are coming into place, when you look at the standards, then how then you deal with the aspect of the trust, the third party. Are we going to play out that person? Again, like I highlighted in the BIS standards, there seems to be a shift from the earlier tradition where we say that you see crypto comes into play to take away the role of the third party. And it is a direct transaction between A and B without the use of C as an intermediary, who is the bank. But from the way the standards have been crafted, if they're not amended or changed, then it seems to have a trend that it may shift the crypto from the current position of being decentralized and rather unregulated into that context of being centralized eventually, which would just be more of appearing to be more of an advancement of the e-transactions, e-payments, or what one can call an electronic payment system that is rather more based on cryptographic proof as opposed to the trust. Then the question as to whether, on instances where there is no globally accepted definition, how the banks are to assess their true risk with crypto assets, and if the accountants or auditors use a different valuation for the assets from the banks, and there is that, of course, fluctuation haphazardly, how does the bank manage its financials or assess its risks? The BIS standards, which I've highlighted in my discussion or presentation, seem to suggest a more detailed, for example, like I said, it does a classification of what some of those assets are. And there's an attempt by those standards to redefine the parameters under which those assets can be used as collateral. For example, the ability to transform them from being traditional assets, rather tokenized traditional asset, the ability for them to be redeemable, but also the ability to sustain the value. The BIS standards also further discuss some of the parameters under which the risks can be ascertained from time to time. But again, also, risk management is one of those areas that every entity, especially when you're dealing with finances, you're going to have to develop some of those parameters upon which you ascertain your risk appetite and how to deal with risk matters when they come in. For example, if you're going to deal with these crypto assets, these digital assets, are you going to look at, for example, ensuring that portfolio, that in case something comes up and then you're not able to recover, you're not able to deal with it as it is, are you going to be able to look at an option of, say, insurance, maybe recover from insurance where there have been losses sustained? But also, it's one matter to contextualize that, again, the aspect of fluctuation, haphazard fluctuations, because then it's dependent largely on the user, from user to user person. Again, another issue I said, you would look at an option of having maybe two securities, have crypto assets on one hand, and then on the other hand, look at things to do with an alternative security that you're able then to recover from that particular security, but also do not lose out totally on the other aspect. But also the limitation of the value that you attach. If someone is going to borrow 15 million, what's the net worth value of the cryptocurrency that you're going to charge? That in the event, and of course, these fluctuations are in this context, how much then, what is the maximum that you can be able to offer that particular person against their crypto assets or digital assets as a collateral? So in such ways, then you would be dealing with those particular risks that submit.
Thank you so much, Timothy. This next set of questions, I will push them over to Thomas. Frankhaus, I hope I've pronounced your name correctly, asks, the crypto is evolving rapidly and positively in the world, but in our region, criminals take advantage to defraud people. How then to detect these criminals to punish them? That's question one. Thomas, you've got the question?
Yes, Leah. Actually, I think if you go further down, there's another participant who's proposed to one of the systems in place, the YEM chain, in response to that question. Yes.
That's Michael Kalisa. Michael Kalisa states as so: there has been systems with a modified blockchain, YEM chain, which I will consider each of you to look into it with its concept. I'm sure you will be answered well as regards to criminal concerns. And digital assets revolution to help you combat with that skeptical concern. He's also attached a link to where you can get the information under the globalization of two organizations, that is unicorn.network and yem.foundation, with a secure application of SafeZone. Then he says, explore the information, you will learn slowly by slowly, but give it your shot if possible. Thank you so much, Paul Kalisa. The next question, Ruth Naziwa asks, thank you for the presentation. I would like to ask you to tell us the cryptocurrency that is going to replace the dollar. I have heard of YEM, that is brackets, rainbow currency. I just wanted to know if it's true. Thomas, Timothy, you can assist on that question.
I'm not sure of Emmanuel, Timothy, but so far we haven't heard of anything in terms of crypto that would, a certain specific currency that would replace USD. Obviously, due to the evolution, as Timothy has said, and I point out in the beginning of the presentation, the evolution is very fast. So we'll probably see a number of cryptocurrencies in the market that keep growing. So I'm not sure if there's one specific cryptocurrency that is set to currently replace the US dollar or any other currency in the world in terms of these big currencies.
All right, thank you so much. There is somebody who says I raised the hand. Idi Kasi, you want to ask your question? Maybe you can unmute and ask. As we wait for Edie, Paul asks Amanya again, as per the best practice, if the blockchain hallucinates, who will, that is, makes up things, who will be accountable?
Okay, as it sounds again like I highlighted, the fact that the cryptocurrency is one that is decentralized on that particular blockchain network or technology. There's rather no single entity or central authority that is responsible for overseeing that electronic ledger. But though, of course, when instances come up, normally the responsibility lies with the particular participants in a given transaction. However, again, these standards that have been put in place seem to put out a different position and seem to be more robust and comprehensive. And I would implore each one of us to take time to try and appreciate those standards by the BIS when it comes to the aspect of cryptocurrency. They try to answer some of these questions, especially when it comes to accountability, value, the risk of assessment rather of risk, and dealing with the same, again, as collateral, but also in a projective manner when it comes to some of these dealings on that particular technology or network.
All right, thank you. I think I'm not able to get EDCAS. I don't have access here to speak only. Grant access. Well, maybe Gabriel, you can assist in granting ED access. As we wait for that, Elson Odongo, you had asked a question. Can we receive perspective of crypto from a Kenyan point of view too? Perhaps maybe I can answer that since I'm on the Kenyan side. Sometime back in December 2015, the CBK, which is our Central Bank of Kenya, issued a public warning on the issue of cryptocurrency due to the aspect of volatility and the lack of specific regulations. And it further clarified that it does not regulate virtual currencies and offers no comfort to members of the public. However, despite the said warning, there is really no law prohibiting their use. However, depending on their nature, various elements of cryptocurrency may be subject to existing regulation. So it's a risky aspect because there's really no protection in the event you decide to take it up. So that's sort of a brief outlook on the cryptocurrency and how our regulator looks at it. Yes. And then Michael Kalisa has also added something regards to the question with Ruth Naziwa. It's not that YEM is here to replace any currency, either dollar or euro, but according to the concept of AIMS of YEM Foundation as stated in uia.org and a global civil society database states that the digital currency YEM is to serve as a global form of payment, a digital currency that would be an addition to the existing global financial system. I think in addition to what has been said, that's an additional information from Michael. Thank you so much, Michael. I think that's just it. Edie, perhaps you can put your question on the chat. Maybe we can be able to assist. Gabriel, are you able to assist in giving Edie access?
Hello, Mr. Lina.
Yes, Edie, you can speak.
The IT is working on it. The ED will be given access just shortly. You need him to speak, right?
Yeah, I can see him.
But what access do you need exactly for him to speak, right? Oh, he's on now. He's on.
Yes, he's on.
Thank you.
Yes, Leah, can you hear me?
Yes, we can. Yes, we can. Thank you.
Okay, thank you to Thomas and Amanya for a wonderful presentation. But I wanted to ask something which is so vital to the whole financial regulations in terms of, I didn't see if we discuss the issue of the threat of cryptos in banks, because now the thing that I can see is most of the countries are hesitating to adopt the cryptocurrencies because of the threat behind. And the threat mostly it's a technology in general, and basically as to who it's the owner of these cryptos. Because now we say some countries establish some certain laws to govern cryptocurrencies. That law govern cryptos, but the crypto itself, we don't know even the person who invented it, who introduced the crypto. We even don't know who is that person. So how is the effectiveness of those laws to this kind of crypto? That's the first question. The second question is the banks, are the banks ready to exhaust this blockchain technology so as to streamline the whole process? Because I can see there are a lot of coins which are introduced. Some of the coins can be introduced in the early year, then you can find at the end of the year, the coin is just fall apart. Now, how can we handle the fluctuation, not only the fluctuation of the prices in terms of those coins, but the introduction of the coin in the portfolio? Because I had an idea, and I think you can correct me, Tom or Amanya, that what if now these central banks, they introduce their own ledger, which can have a portfolio of the coins which are trusted within the central bank, so that people can use them as collateral and other financial access. Can it be possible? And if it's possible, now why are we there yet? Because now we're dealing with a creature that is unknown. For instance, you mentioned about Satoshi Nakamoto, which is unknown to most of the cryptos owners, but people still own them. Now, how can we deal with this? Because we can establish a law, yes, the law governing cryptos and everything, but who is the owner general? Now, can we transform the ownership from unknown creature to the central bank, who can own this ledger and which can contain a certain portfolio of the cryptos which are secured and everything? Now people can have that trust and everything. Is that possible? That's the second question. The last question is the insurance. I mean the whole essence of insurance, and now that the because now we're talking about crypto markets. Now it goes further to the other area of insurance. Now, are insurance companies ready to deal with this kind of transaction? Because we're dealing with the market, which is a lot of volatility, a lot of threats, in terms of cyber attacks. And are we sure that our insurance industry is ready to welcome those kind of this kind of sector, so that people can even be more secured on this angle? Those are my questions. Thank you so much, Leah, and for wonderful presentation from Amanya and Thomas.
Thank you, Edie, for that. Maybe Thomas or Timothy can assist.
Thank you, Leah. I mean, I think this is what the general discussion now is around cryptos. As we say, it's an evolving area of financial practice. And to put your questions into perspective, obviously the biggest challenge you have for most governments is the fact that the cryptos are decentralized. So associating the associated risk there for participants obviously is some of the things that have been mentioned, like getting into defraudment, etc. But in some jurisdictions, like the US, they do have a system in place. For example, where they call them SARS, so you report suspicious activities, and then the authorities will try to detect what is happening. Some of the ones that have been mentioned, like YemChain, there's also a system that to detect some of these activities. So for jurisdiction purposes, the biggest challenge for cryptos being decentralized is how are you going to create a regulatory authority that can oversee the trading, how you put a system in place for KYCs, etc. We've mentioned all these things. So I think as a region, it is high time, like Timothy said, that we look at this in a more serious manner in terms of how it can help the regulatory framework and the responsible bodies who draft these legislations to allow for crypto to be formalized through proper regulations, which will obviously provide issues of dispute resolution and how to control participation. So that will take time, obviously. In terms of insurance, obviously that's insurance agencies have a risk assessment. It will depend on the type of crypto that the insurance agencies would have appetite to insure against. I haven't seen anything in the region, but I don't know if anybody else who's here has. Maybe they can share their insights there. That's all I can share for now.
Thank you so much. Timothy, any additional comments?
Not much really, but I think that, of course, eventually once it's bought into that, you need to use these cryptocurrencies. Oftentimes, these insurance groups are driven by the market demand, and what is out there for them to offer. Of course, once these portfolios have been adopted, and then banks do allow to use them, and they're going to take on this particular aspect, then it would interest insurance companies in being prepared. Of course, there are those that move ahead with strategy in their strategy, and they're looking out to these markets and saying these are potential clients. See, the banking sector is what it is right now, and of course we need to look at that possibility when that time comes. How prepared are we when it comes to those things? So, of course, one of the aspects again is to embrace when it takes center stage. Of course, in some nations it has been taken on. When in the region it starts taking center stage, then there's need maybe to do some trainings for these insurance groups, try and embrace the use of these cryptos, and basically try to guide on how to do the packages, make sure that maybe they are within both stakeholders, the bank and the insurance themselves, not to lose out on those cryptos. And when it comes to the aspect of the CBCs, central bank, digital, the current trends where the central banks are trying to create their digital currencies. Again, it goes to the Basel framework. And we know that the Basel framework is really that set of standards that this committee, the Basel Committee on the Banking Supervision, or what we call this BCBS, has tried to set, because we know that this is a pace setter. It's more of a standard setter at the global level. when it comes to some of these aspects. Question is when these standards come into play. When you look at 2025, will the central banks have adopted their own the CBCs, will they be into play that at that time then those standards will be rendered nugatory? When you look at the current volumes, they're talking about $2.95 trillion in circulation in the asset cover when it comes to the cryptocurrencies. That would be huge. Maybe one can say, has it reached that point of the too huge to fall? That we've reached a point that we need to adopt and see how do we move forward with this current trend that comes with the use of the crypto.
All right, thank you, Timothy and Thomas. Michael has raised his hand. Michael, you can unmute and ask. Michael Kalisa. Okay, as we wait for Michael to speak, there's some additional comments and questions. Erisa Tuga asks, many elite people are relaxed to embrace the growing crypto technology, even those in administration. How can those be brought together, especially ministers of finance of East Africa, to teach about cryptocurrencies? That's a comment as well as a question.
Yes, hello, Sole. Am I being heard by everyone?
Yes, Michael, we can hear you.
Yeah, okay, wonderful. Thanks for this opportunity that you've given me so that I can share my voice. Actually, for me, I'm not having a question. I'm just providing a supplement to what one of our friends has provided. What we need to know in this revolution is, first of all, governments and banks are in a skeptical moment. They thought that this will not go further, and they neglected it, they ignored the issue. But as time went on, due to the revolution of Bitcoin and other blockchain-based assets, they have seen that now it is the time for them to intervene. And they are not making regulations to protect us. The fact is they are making regulation to stay in control, whereby people have already seen the light. But since they still have the power on the monetary system, they can still have the way to make us panic and they control. And we need to know that within this revolution, cryptocurrency is just a drop of water on this technology. They have left out the big player of the technology, which is blockchain. Now they are putting much effort on cryptocurrency, which is money, because their mindset is in control of money, but leaving out the blockchain base, which is taking each and everything. And even with the youth, when you look at, most of us are not informed about this information. We are just in the meme sector of looking at only the cryptocurrency. And what I can even, the idea I can guide to the banks is that banks thought that they are the only players in this game, and they remain in control, not knowing that it's not banks who are controlling people, it's people who make money to control banks. But people are provided information which give them a myth, which give them an understanding, knowing that it's banks which control them, yet they are the one who control them indirectly. So when people diverted to cryptocurrency, banks reacted. And as of current, because of the centralization and whatever, banks are starving because people can make transfers and whatever, which is the same to the government. And what do? They have to put laws that bring down the whole system so that they make a resolution or resilience to come up with another control to them. And in the crypto world, these intellectuals, what they need again to know, it's not about regulation, even though it is effective to have a control for the bad guys, but it is about infrastructure. Anything to move very well, we must find a right system with infrastructures. Many cryptos are coming as scammers, as whatever and whatever, but finally we shall need to join a system with the best infrastructure. Best infrastructures in digital communication and in digital transitions and in financial digital transition that are integrating with the government institution, with laws. That's why I've given you one of the companies that I'm not marketing to you, but at least since we are in the revolution state, in globalization state, whatever, we need to look at the companies that are stood the test of time. It may not act exactly what others think, but we look at the infrastructure behind. We look at their engagement with the laws. We look at their development and creation to give a shot to people and to give as well a way for the government to interact with them. So those were my few supplements to you members, but I'm so happy that at least we provide such an international platform to each and every member so that we can give you, because it is through learning that we can get to understand this resolution. Otherwise, if we don't give a way to understand each and everything and we look at how we can make exchange and liquidity stuff, we may fail to get the best shot in this wealth creation. And let us don't forget that there is where the wealth is in transfer. But at the end of it all, gold standard is coming back as it was started at first. Thanks for listening to me, guys. And let me tell you that I'm so happy to interact with you. I'm Michael Kalisa from Uganda.
Thank you so much, Michael, for that contribution to the topic. We really appreciate. Finally, Eddie Cassie has also additionally indicated central banks should exhaust the blockchain technology so to streamline the whole process and not taking it as a threat to banking industry. The future is eCoin, no doubt. I agree with this. I do agree. Then Pani says, hello, thank you for the in-depth presentation. And Irene Sisi says, thank you so much. Michael Kalisa, thank you, Sisi. We just have a few minutes just for one more question for Joshua. I don't want to skip him. He asks, the U.S. Securities and Exchange Commission has filed a total of 13 charges against Binance in U.S. federal courts. The core of the CEC's complaints against Binance and CEO Tao is that the company knowingly heated U.S. regulations and deceived U.S. and regulators about how it was operating its exchange. What is the potential impact of this lawsuit on crypto assets as a whole? Timothy, you want to take that up? Timothy, or should I repeat?
I lost you midway.
Oh, sorry. Let me just come again. Joshua says the U.S. Securities and Exchange Commission had a total of 13 charges against Binance in U.S. federal court. The core of the CEC's complaints against Binance and the CEO Chao is that the company knowingly cheated U.S. regulations and deceived U.S. investors and regulators about how it was operating its exchange. What is the potential impact of this lawsuit on crypto assets as a whole? That's our final question.
Of course, the fact that Binance happens to be one of the world's largest cryptocurrency exchange. There have been, of course, those threats. Of course, when those matters have been filed, when that matter was filed, and of course, following that previously the second largest crypto exchange forum, FTX, also had collapsed the previous year. There have been all those fears that there would be, perhaps with that case, given the direction it would take, there's a possibility that then it would have an effect on the possibility of the growth of cryptocurrency as a trending finance use. I want to disagree and think that, of course, all those challenges are notwithstanding, and many other to come, because of course, like I said, one of the issues is that the central banks tend to look at it as a threat to the banking sector as opposed to how finding a way on how they can use or work concurrently with this particular technology. And so there's that panic of trying to create situations here and there, non-recognition, putting in place laws that are tending to try to fight some of those aspects. But also one would understand the aspect of protection, the right of the state to protect its citizens from such transactions. If people are going to be defrauded, if people are going to lose money, especially those huge investments when it comes to those so big crypto institutions such as Binance. But of course, the future is crypto, given the trends and the dynamics that are going on right now. And I think it's high time we embraced and see how to safeguard and also to use it cautiously where possible. But of course, it's one area that is growing, and therefore each stakeholder has a role to play when it comes to the policy, to the regulation, and you as a person who is going to use it. If you choose to use it, what you have to put in place to make sure that you're safe and your monies are safe and you're not going to be defrauded or lured into a loss at a later point. So amidst all those wins, because you see, even after FTX had closed, still people have proceeded to use cryptocurrencies, and like I highlighted, by the end of last year we had over 9,000. So it's something to embrace. I mean, it's the challenges, and let each stakeholder play their role where you're seated at. Look at what you can influence. Is it policy? Is it putting up a mechanism? Perhaps you may develop something that is going to come up and say, maybe checking the anonymity, helping with the due diligence. It's time to create those innovations and inventions. I beg to submit.
All right, thank you so much, Amanya. Mujulizi, we've seen your comment that we need to be able to unlearn and embrace the emerging trends, which I agree, dynamic and volatile challenges to the conventional legal framework. Thank you so much. Thank you all for participating. We really appreciate. Thank you to the panelists and everyone. I hereby call upon Gabriel to make the final remarks. Thank you so much.
Thank you so much, Leah. Excellent moderation skills. I have been enjoying this session. A very special thanks to you, Mr. Thomas Ngulume and Mr. Amanya Timothy. Thank you so much for sharing your very insightful views on cryptocurrency. Indeed, crypto is the future, and we need to prepare ourselves accordingly for the future. On behalf of the Secretariat of the East Africa Law Society, I would like to thank you so much for taking off your time and delivering a very stellar presentation during this capacity building session. Ladies and gentlemen, on the session, on the call, I would also like to thank you all for taking off 2 hours of your time, very busy schedules, to be part of this very informative session. I have seen quite a number of senior counsel on the platform, and I'm really honored to have you. I've seen our past president. He's been on the platform, and I'm sure he's been following in closely. So we'd like to thank you all for being part of the session. We'll be issuing out certificates of attendance after the session. So when you receive an email from Diwala offering you a certificate, please do not think it is a scammer. It is an initiative that we came up with at the Secretariat to appreciate you for your time. So every after our capacity building sessions are completed, we issue you with a certificate for your reference purposes. I would like to inform you that we'll be sharing with you the presentation that has been made by Mr. Amanya. I know quite a number of you have been requesting for that presentation, so I'm going to request Mr. Amanya after the session to share the presentation with me so that I can be able to share with the rest of the participants so that they can keep referring to the same. I just have 2 points of announcement from the Secretariat. For starters, because we're in a banking and finance session, ladies and gentlemen, allow me to announce the East Africa Community In-House Convention 2023 will be taking place on the 27th and the 28th of July 2023 at the Madinat Al Bar Hotel in Zanzibar under the theme the future of in-house counsel in cross-border cooperation. The convention costs only $450, and it's going to be the largest gathering of in-house counsel in the East African region. Therefore, I highly encourage all of you working in the in-house counsel departments of your different corporations to take part in the convention. I would also call upon the colleagues who are in private practice but are interested in in-house counsel to be part of this. You will have the biggest multinational companies also taking part in the convention. A number of relevant national and regional bodies will also take place during the session. I'm sure you'll get the benefit of meeting and interacting with your colleagues engaged in in-house counsel practice. And we have quite a number of insightful topics for you. I'm sure you've seen our flyers and brochures going around, and we hope to see you in Zanzibar. Relatedly, ladies and gentlemen, I would like to invite counsel who are interested in legislative drafting and leadership. We have a training on legislative drafting on the 3rd to the 7th of July at Mount Meru Hotel in Arusha. Come and join our panel of experts as they take you through legislative drafting. I'm sure you will have quite a lot to gain, but also to meet and interact with the region's best legislative drafters. That training will cost about $600 that will cover for the conference and training facilities. That said, I would like to thank you once again for taking part in this webinar session. I'd like to thank our panelists, and we'll be sending the materials to you within the course of the week. I'm sure you'll receive them. Otherwise, from our side, we wish you all a very lovely afternoon, and may God bless you all. You can now exit at leisure. Thank you.